Welcome to this installment of Clarifying Tax Situations with attorney and CPA David W. Klossing.
What constitutes full disclosure in a divorce? Almost every state in the Union is going to require a full disclosure of all of the assets that make up the marital estate, each spouse's husband and wife's claimed separate property, and each husband and wife's separate income earning capacity, items of income. All community property and common law states require the disclosure of all material information that the court deems necessary to facilitate either the parties to negotiate or mutually agree upon, or the courts, if necessary, to adjudicate upon and reach an informed division of marital property. California Family Code 721 specifically mandates that in California, married couples are subject to the fiduciary rules that are imposed on persons involved in confidential relationships. Furthermore, California Family Code 1100E requires spouses to make a full disclosure of all material facts and information regarding the existence, characterization, and valuations of assets in which the community may or actually has an interest in. To ensure compliance with each state's full disclosure requirements, advisors to husband and wife should make sure that the parties inventory all assets, including intangible assets such as advanced degrees, patents, goodwill, and other things that can result in a generation of substantial income over future years, especially after the divorce. Over time, the courts have been demonstrating an increased willingness to either classify the intangible assets as property subject to valuation and distribution, or where they can't, to require spouses that solely benefit by an intangible asset, i.e. somebody that's earned an advanced degree, to reimburse the non-benefiting spouse with a like allocation of community property assets. There's a presumption in most states that all property acquired during a marriage is marital property subject to being split between the parties. A couple exceptions would be inherited or gifted property. That becomes the separate property of the person receiving the gift. Also, technically speaking, retirement benefits under ERISA are separate property, but state laws ultimately dictate the legal division of marital assets in a divorce, including pension plans under ERISA. Frankly, a lot of states differ on which spouse gets what property in a divorce. Most of the variation among the states turns on whether the divorce takes place in an equitable distribution state, a common law state, or in a community property state.